Thanks very much, Lascian Corla. This is a matter that I've been trying to get information on for some time now, and it's proving a little bit difficult. I asked a parliamentary question with respect to how many persons whose application for international protection had been determined and where there wasn't a judicial review of that. In other words, it was a determination which was accepted and was not under legal challenge, who were still in IPAS accommodation. Now, I asked the question, I believe, in November. At the time, I was told that there were some 6,000 people who had been granted either international protection or international leave, or humanitarian leave to remain, who were still in accommodation, and that the Minister was making efforts to slowly transition them, or not the Minister, but IPAS was making efforts to slowly transition them out of IPAS accommodation into alternative accommodation, starting with people who had received status 3 years previously. However, that doesn't fully answer the question, because there are two other groups of people who are no longer applicants for international protection, whose application for international protection has been determined, and that is people who've been refused international protection and refused leave to remain. I haven't received a definitive answer on that. I was told that there were people in respect of whom deportation orders had issued, a small number who are still in IPAS accommodation, but there's still a much larger group of people, and that is people whose application for international protection has been determined. As the Minister will know, the International Protection Act has effectively a three-stage process. You apply to the IPO for international protection, you're either, and simultaneously leave to remain, you're either refused or granted. If you're refused, you can appeal the refusal of international protection, but only international protection, to the IPAT. So you don't appeal the refusal of humanitarian leave to remain. And then IPAT makes a determination. And then, following receipt of that determination, if it's a negative, you can then apply for humanitarian leave to remain. And that's a process that's taking a very long time. There's a large number of people backed up. The Minister for Justice refuses to tell me how many people are awaiting a determination on whether or not they're going. You've only have, by the way, 1 week to make that application. So it's a very short time frame to make the application. That implies a degree of urgency, yet unfortunately it's not treated like that by the Department of Justice, because anecdotally, the Minister refuses to give information. Anecdotally, I'm told that there are people waiting months, years for that determination. But why is that important? That's important because the exemption that applies in respect of IPAS accommodation, that planning exemption, is in respect of people seeking international protection. And international protection is to be defined by the International Protection Act, and that specifically talks about refugee status or subsidiary protection. So that's international protection as opposed to humanitarian leave to remain. So once a person receives an IPAT determination, be it negative or positive, they are no longer applicants for international protection within the meaning of the planning exemption, and importantly within the meaning of European law. And of course, Ireland has a duty to provide accommodation to applicants for international protection. So once that's determined, the duty ceases. There may be duties elsewhere, as in the general housing list for persons who are homeless, but there isn't a planning exemption to move a busload of people who are homeless into an area and avail of a planning exemption. It simply doesn't exist. So my fear is that, inadvertently or otherwise, the system as it now exists is abusing planning exemptions. And I look forward to the Minister's response.
Thank you, Lascian Corlan. Thanks the Deputy for facilitating me to be able to address this question directly to him. So IPAS is currently accommodating about 27,000 people in over 200 accommodation centres throughout Ireland. And of the 27,000, 5,914 have been granted status. So under the Reception Conditions Regulations of 2018, those who have had their application determined are no longer entitled to material reception conditions. So the International Protection Accommodation Service, IPAS, continues to provide accommodation to those with status while supporting them to progress into the community. All those with permission to remain are written to once status has been granted, and they are advised that they may now seek alternative accommodation. They're also advised that the supports of the Peter McVerry Trust and DePaul are available to them. Those with status for the greatest length of time are currently being offered a transfer to alternative emergency accommodation. So in the last 12 months, over 2,000 people with status have left IPAS accommodation and progressed into the community. And this process began in September 2022, beginning with single applicants with status for over 3 years. So currently, single adults and couples with status of over 12 months are being notified of the offer of emergency accommodation, and if they've been unable to source accommodation within 6 weeks of the dated letter. So to date, 1,256 households have been written to and advised that this transfer to alternative emergency accommodation. And of these households, 745 have left IPAS accommodation, 96 availed of the offer of emergency accommodation, and 415 households are still in this process. Those over the age of 65 or with significant medical or welfare needs aren't transferred to the emergency accommodation. IPAS has set up a specific transition team who work in collaboration with DePaul, Peter McVerry Trust and the Department of Housing and local authorities to support residents with status to exit IPAS accommodation and access other housing options. In the interest of clarity, and maybe to address one of the Deputy's points, I'd just like to outline that an applicant is entitled to accommodation until their application, including the permission to remain review phase, is fully completed. There's been some confusion that once the refugee and subsidiary protection decisions have been completed at appeal stage, that an applicant has completed their international protection application and is no longer entitled to accommodation. That's not the case. The permission to remain review phase and the subsequent decisions by the Ministerial Decisions Unit must be finalised. And until all of these steps have been completed, an applicant is entitled to accommodation. There are currently 134 people residing in IPAS accommodation who have their applications determined unsuccessfully and have been served with a deportation order under the International Protection Act. And IPAS is informed when an application for international protection has been determined by the Department of Justice, and when a deportation order is issued, its enforcement is a matter for GNBI, but my department works closely with the Department of Justice and GNBI in terms of implementing and supporting the implementation of those orders. Those with permission to remain have the same housing entitlements as Irish citizens. The NGO partners put in place by my department support them to register with a local authority and to avail of the housing assisting payment to secure alternative accommodation. As you know, they have the same social welfare entitlements as Irish citizens. The policy of writing to those with permission to remain with status has been granted, and advising them they must now seek alternative accommodation is in place to ensure that accommodation in non-emergency settings is available to newly arrived persons seeking international protection. And as we know, that's a significant number, and there's a significant number we're unable to accommodate right now. So look, Deputy, I think I've been able to provide you with numbers for 2 of the points you've asked. I don't know. Can we break that third category that you put there? I don't know, but look, I'll certainly endeavour to see what I can do on that point.
Thanks very much. Minister, you are right that under the domestic regulations, the statutory instrument, there is a right to accommodation until such time as your humanitarian leave to remain application has been determined. I've outlined the delays and the difficulties, which can't be laid at your door there at the Department of Justice, that pertain to that. But the bottom line is that that's only a statutory instrument. That can be changed at the flick of a pen, literally. And you have done that. You have amended the regulations because there is no right under European law. And we're constantly being told that this is a matter of European law and we have to accommodate applicants for international protection. Yes, we do. But applicants for international protection is defined in European law, and it is defined in the International Protection Act 2015 as an applicant for refugee status or subsidiary protection. So once that application is determined, you are no longer as a matter of European law, you no longer have an entitlement to accommodation. And you, importantly, a centre accommodating such people, because of how the planning regulations are termed, no longer enjoys exemption. Yet I'm aware that there's a ping-pong, a row going on. It's the Irish Times published extracts from correspondence between your Secretary-General and the Secretary-General of Minister O'Brien's department as to who is to accommodate these unfortunate people. But the bottom line is that it is not exempted unless it is accommodating applicants for international protection, not people who enjoy international protection and not people who are waiting for their humanitarian leave to remain. There is no exemption for those categories, yet those people are being are the subject of an interdepartmental row, which is unfortunate, but it is also very unfortunate if the use of a blanket exemption, which avoids the normal planning process, which avoids consultation with communities, is being used unlawfully. It's more than unfortunate. It is unacceptable. So that is why it is important that you clarify that other category that I've asked you to clarify. You said you don't know if you can break it down, but you need to break it down to ensure that the exemptions are not being used unlawfully, because we have to distinguish between people who are applicants for international protection who enjoy rights under European law and persons whose application has been determined who no longer enjoy those rights. They may have a right, if they're lawfully resident in the state, they may have a right to housing, but it is not in an IPAS centre. It is in an IPAS centre, but it's not pursuant to European law, and it is not in a place, if they're staying there, is not an exempted development. Thank you.
Minister.
Thanks, so the Deputy has raised his reading of the law, and respect that. I don't have the EU legislation, the primary or the secondary, before me right now, so I'm sure, I've no doubt, and I don't need you to. I'll be able to get them myself, and thank you for the offer. So we'll examine the point that the Deputy has made. I suppose to speak to the wider issue, the Deputy is absolutely right. There is real pressure there in terms of providing accommodation, for people arriving here, many highly vulnerable people seeking international protection here, and in terms of wanting to support those who have a decision to move on throughout the process. And we have put in place important steps to streamline that process, to provide additional supports, because it is right that when persons have received status, they are in the same position as someone who is already resident here. They have the same rights, and they face the same challenges in terms of securing housing and so in terms of securing other accommodation as well. And as a department, we are making every effort to ensure, where we have accommodation secured in centres all over the country, that we get the absolute best benefit from those centres. And we spoke yesterday in terms of ensuring that we get the maximum occupancy in our centres. And I spoke again to my officials about that today, and they assured me we're going as far now as moving people individually within hotels, a family of 4 out of a 5-bedroom and into a 4-bedroom, things as basic as that, to ensure that we get the maximum occupancy, because we are under so much pressure right now. But Deputy, I'll endeavour to see that more granular breakdown if that's something that we can ascertain.
I hope it will be stronger than strive to endeavour, whatever is in the will actually happen.
We go to the third item which we've selected.